Welcome to Canadian Justice. I'm Christine Van Gyn, and today I'm chatting with Assistant Professor Geoffrey Sigalet, the director of a brand new and exciting project, the University of British Columbia Centre for Constitutional Law and Legal Studies. The UBC Centre was created to help facilitate research on issues in constitutional law, constitutionalism, the rule of law, the separation of powers, rights and liberties, and the philosophy of law and related legal topics. The center also helps students interested in these areas of research and helps students create and maintain connections with the wider legal community. The center hosts speakers, workshops, conferences, and reading groups, and aims to help support the funding of legal scholarships. They have just wrapped up their inaugural conference, which was what actually hosted a Supreme Court judge as the keynote speaker. Now, full disclosure, I am very supportive of this new initiative, and I'm listed as a center associate. Now here is Geoffrey Sigalet to tell us more about this new project. Jeff, thanks so much for joining me today. Let's start with what you can tell me about the new project. What made you start the new initiative?
Thanks for having me, Christine. I'm delighted to be on Canadian Justice, I'd say that what really got me interested in starting this project was, first of all, just having experience as a postdoc. Before, I'm a brand new assistant professor. It's like the baby version of a professor. And before this, I was in several different postdoctoral fellowships at McGill, at the Research Group for Constitutional Studies there, and which is run by Jacob Levy, and at the Stanford Constitutional Law Center, which is run by Professor Michael McConnell, who's a former circuit court judge, and I was actually also briefly at Queen's. And my experience in these kinds of centers is that they're really useful and fantastic institutions for bringing together more legal research, bringing together people with different points of view about these things, and just getting more education and research activity going on issues in constitutional law and constitutionalism. And I wanted that to be the case wherever I ended up academically, and so it was just a no-brainer to try to start this. I say no-brainer, but it takes a lot to start something like this, and baby professors have trouble starting things along these lines, so they need help from grown-up professors. And I'm so lucky. I've had a lot of help from my senior colleagues here. When I pitched the idea, that everyone was very supportive, and things got off running real fast. And I should also say that another fundamental. So one part is just being really concerned about and interested in having a robust and vibrant research community on constitutional law here at UBC. And the other concern is I am broadly fairly concerned with the lack of viewpoint diversity in the legal academy, and actually just in the academy generally.
Yeah, that's one of the things I wanted to ask you about. Do you think that an organization like this, and I've looked at some of the people that you have listed, and there's a huge diversity of viewpoints among your research associates and center associates. Frankly, a lot of observers think that among academia, there is a lack of viewpoint diversity, a lack of debate, and a lot of academia seems very one note. Do you think that this center is going to help change that?
Look, it's just one little center, but I think you're right that the observers see a problem with viewpoint diversity in the Canadian Academy and the American Academy, for that matter, and it's not just anecdotal. MacDonald Laurier released a study a few days ago where they found that like just 9% of professors or something like that openly admit to being conservative. That's insane. There was a Main Street poll the other day showed that 40% of Canadians might vote for Pierre Poilievre, who's, if nothing else, he's probably pretty conservative, right? And so to have 9% of the professoriate versus 40% of Canadians identify that way, potentially, whatever the disparity is at the moment, it will obviously change depending on the political moment. It's just clear that there's not a lot of right of center views in the academy, and that's a problem, and it's a problem for the law and the legal practice insofar as ideology can affect and influence lawmaking and lawyering, right? And so I think that the center, it's not designed to be some kind of way of injecting a whole one perspective into things, but rather fostering a variety of perspectives in a way the academy hasn't done a good enough job of.
And it's sort of part of the purpose of the academy is to have open conversation and debate and free expression. We got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're talking to Assistant Professor Geoff Sigalet about his new initiative, the University of British Columbia Centre on Constitutional Law and Legal Studies. Now, Geoff, one of the things that you have said that the center is designed to facilitate is research into constitutionalism and the rule of law. Now, for our viewers, what do those terms mean and why do they matter?
This is a very deep question that is really going to have you thinking more in the morning here in British Columbia than I'm used to, maybe. I think constitutionalism, both of these terms, constitutionalism and the rule of law, are not neutral. They're not value neutral terms. They're terms that come laden with commitments that we can think of broadly as in the liberal democratic tradition. Constitutionalism, generally speaking, is the idea of constraining state power and channeling it in specific ways, so that political institutions are not just subject to the whims of arbitrary whims of whoever happens to control them, but are themselves actually constrained and organized in different ways by specific kinds of rules and rules that involve coordinating and ordering institutional power in ways that maybe restrain state power and channel in specific ways. Now, that's a kind of that's trying to not get too controversial about the idea, because then, of course, we try to nail it down a little more narrowly. We start getting into very specific views. There's very substantive views of what constitutionalism is, and I don't want to have my own view and preference about how to think about that, but I admire and respect people with very different conceptions of it. And the same goes for the rule of law, right? The rule of law is itself, it can be thicker or thinner. You can think of it as fat or skinny. If you want the fat or thicker idea of the rule of law, it's this set of very substantive commitments that maybe even includes certain kinds of rights. And a thinner idea of the rule of law sort of leans back into a more, almost starts to sound a little bit more like the more abstract conception of constitutionalism itself. That the idea that political power will always be subject to specific kinds of rules that ensure that proper procedures are followed, and that can be quite thin insofar as you could just have the idea that, well, you need to always have a very thin idea of due process. And you can think of the rule of law as, I think, has actually traditionally been understood and associated with that idea of due process, and the more substantive version of it has been sort of theorized and developed as certain courts have famously articulated ideas of substantive due process, right? This is a substantive idea of the rule of law. It's actually existed in jurisprudence, not just in legal theory.
Now, these principles are sort of fundamental to liberal democracies. They're not necessarily a right-wing or a left-wing ideological conception. Can you explain how the concepts of constitutionalism and rule of law fit along that political spectrum, if at all, for our viewers?
Well, the way that constitutionalism and the rule of law don't quite align with right or left-wing ideology or the particular views of particular conservative or liberal partisan political parties of the day. That is something that is, to me, one of the reasons I'm in this business of thinking about this stuff is I find that really fascinating. And I think that constitutionalism itself, insofar as you're interested in that project of constraining state power, you got to constrain power for people who agree with you about certain kinds of substantive policy ends and people who don't. You have to design constitutions such that power will not be used arbitrarily, just depending on who agrees with you as being in power, right? And same goes for the rule of law. The rule of law, if it means anything, it doesn't just mean that when your team's in charge, the rules are what they say they are. It means that there's some conception of what kind of procedures and processes apply to whoever is in power.
And these are principles that are so foundational, and they get lost. They get really lost in our increasingly polarized world. And I think it's so important to remind all of our viewers about these foundational principles. And I think that that is one of the amazing things about the research that your new center is going to be undertaking. I'm so excited about it. And I'm so excited that I'm going to be listed as a center associate. What we're going to talk, we've got to go to break, but when we come back, we're going to talk about who the center associates are, who the research associates are, and what all of that means. Welcome back to Canadian Justice, where I'm chatting with Professor Geoff Sigalet about his new initiative, the University of British Columbia Centre for Constitutional Law and Legal Studies. Now, Geoff, the center has a list of research associates and center associates. Who are some of the research associated, and is there sort of a common thread that ties them all together? Now, I've seen the list, and it is incredible. It's some of the most fascinating legal scholars in Canada. Frankly, it's like a dream list for a guest list of an episode of my show. So how did you select them?
Well, I have to say there wasn't that much method to the madness on the selecting. It's just people I know of in my research networks that are, first of all, very doing interesting research, I think, from a variety of different kinds of perspectives.
Can you give a couple of examples?
A couple of examples are, one example might be Professor Dwight Newman, the University of Saskatchewan, Canada Research Chair in Indigenous Law, and he is a fantastic example of someone who is just very influential in Canadian constitutionalism generally on almost every single facet, right? And cited by the Supreme Court on a regular basis. And I'm a big fan of Dwight and wanted him to be part of this, and he's participant in one of our first workshops that we had here. Another example would be Professor Gregoire Weber, is the Canada Research Chair in public law and philosophy of law at Queen's. He's a big mentor of mine, and I absolutely wanted him to be part of this because I think his scholarship is unbelievably good, and it's been very influential on me. But other scholars we even have scholars outside of Canada, like Rosalind Dixon, who is one of these scholars who's written about dialogue and has been very influential in my own work. And is a professor at the University of South Wales in Australia.
Is there a common thread to connect all of these professors and research associates together?
Well, I think the common thread is they're all interested in good faith debate about fundamental issues in constitutionalism, and they represent a variety of perspectives about that. And there's another thread, which is that some of them are law professors, and some of them are political scientists. So we have very well established and fantastic political scientists like Mark Harding and David Snow at the University of Guelph, Dennis Baker at the same university, and Troy Riddell. Sort of, there's a team Guelph. I think that Guelph is a great place to go for an undergraduate degree if you're not going to come to UBC Okanagan and study with. Other political science, we have like James Kelly at Concordia. And so we have a mix of political scientists and legal scholars, and all of them do really interesting research on constitutionalism, on these major themes in constitutionalism and the rule of law we talked about in the last segment.
Now, you also have what's called center associates, and I am a center associate. So what do you see the role for people like me who are center associates?
Well, one of the ideas we have here is we want to build connections not just amongst legal researchers, but also amongst legal practitioners, because, of course, the legal practicing community is the one that picks up research and uses it. And so having legal researchers like yourself, having practicing lawyers like yourself who are interested in these fundamental questions involved in the center going forward is a really great way of fostering that kind of connection and making research matter, right? Mm-hmm. So when you come to a future event, it's going to potentially, you're going to hopefully hear a paper that you then use in one of your arguments for the court, and then the court picks it up,
Yeah, and I can't wait. I unfortunately wasn't able to make it to the inaugural workshop, which I would have loved to go to because it was in beautiful Okanagan. The topic of that workshop was theories sorry about that, theories of charter interpretation as they relate to political institutions. So can you explain, we've got about a minute, what in plain language, what does that mean?
Well, we're very interested in how different theories of how to interpret different sections of the charter relate to the relationship between different kinds of political institutions. So let's say an obvious example of that is like Section 33, the notwithstanding clause. How do different interpretations of it relate to the ability of courts to potentially review or potentially not review and laws that invoke Section 33? And what does that mean for understanding the broader kind of system that the charter regulates?
Mm-hmm.
And so those kinds of questions are what we explored in the workshop.
Now, at the workshop, the keynote speaker for the conference, you had an incredible keynote. It was Justice Suzanne Cote from the Supreme Court. We've got to go to commercial break, but when we come back, I want to hear about what Justice Cote talked about and what some of the takeaways from her keynote speech were. Welcome back to Canadian Justice, where we're chatting with Assistant Professor Geoff Sigalet about his new initiative, the University of British Columbia Centre on Constitutional Law. At your inaugural conference, you had Supreme Court Justice Suzanne Cote present. What did she talk about?
Well, she provided a kind of bird's eye view of 40 years of charter jurisprudence and some of the most significant threads that lie through that. And something she really picked up that were really interesting, where she talked about the need for the primacy of the text and how that's become more important in recent cases, like the recent City of Toronto case. And I find it very fascinating. And I got to say that the talk itself was excellent, but the Q&A back and forth, which we didn't film, we cut off because we weren't sure who might say what in the audience. We slid over to Q&A without filming it, and I gotta say, in live it was fantastic. She handled the questions very well, and she didn't say anything inappropriate, given her the need to not comment on cases that might come before her and or indicate how she might prejudge the law. But she did engage, given those limitations, she engaged very substantively with some really interesting questions from audience members who ranged from defense lawyers who wanted to just praise her for some of her dissents to audience members that had really never really thought about the charter much and were just curious what she had to say about it.
I love to hear about primacy of text, which is something that we care a lot about at my charity that I work for, the Canadian Constitution Foundation. And that case, the City of Toronto case, was such an important one that we intervened in, related to whether or not unwritten principles can displace legislation. And I wholeheartedly agreed with Justice Cote's interpretation in that case. It was a wonderful case, a great result for our organization. Now, the workshop also included the presentation of working papers by different scholars on how questions of charter interpretation are tied up with functions of Canadian political institutions. So can you give me some examples of some of the papers that were presented?
Sure. Well, we had Professor Malcolm Lavoie from the U of A talk a little bit about Section 6 of the Charter, mobility rights, and how they actually kind of implicitly show that there's some economic rights in the Canadian Constitution, and the judiciary may have some role in enforcing that. Whereas much of the rest of the Constitution leaves out significant kinds of property rights that are suspiciously absent as a direct right within the Charter, and that is partly an institutional question. That means that protection for property rights is partly left up to the way the division of powers guarantees the property rights will be primarily dealt with by the provinces, right? And so he had a really interesting take where he combined both thinking about how the charters, how to interpret the charters approach to property rights, what parts of the charter actually might relate to property rights, then how that related to different institutions. We had Dwight Newman talk about how there's this originalist argument for Section how Section 28, the guarantee of sexual equality in the Charter, might actually let courts override uses of Section 33 relating to sexual equality. Well, that's really fun because there's it's a feminist originalist argument taking seriously the text of the Charter. And he had made a great case against that argument, arguing that that original meaning of Section 28 is hard to square with an idea that 33 is overridable, notwithstanding whatever the intentions of some groups that wanted Section 28 inserted and might have desired.
Fascinating. So we've only got about 30 seconds left. That was your first event. What events do you have coming up? Anything that you can tell us about?
Well, I can't say for certain, but you can look. We're going to have a few visiting speakers this year, and we're really excited about that. And they may or may not include some very interesting commentators on constitutionalism as an idea and in the history of political thought, let's say. And we will undoubtedly have another public lecture and workshop next September, and it may involve a certain other Supreme Court justice.
Awesome. That's all the time we have. Jeff, thanks so much for coming on.
Thank you for having me.
We've heard today about a new initiative at the University of British Columbia focused on constitutional law. Will this initiative encourage debate about legal issues, philosophy, and ideology? Can we create and encourage more diversity of opinion within universities through initiatives like this? And how can an initiative like this help the public better understand our fundamental rights? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.